This video examines the Supreme Court decision in Reyes versus the Deputy Ombudsman for Luzon. We will analyze the court's ruling regarding probable cause under Section 3E of the Anti-Graft and Corrupt Practices Act, and review the specific disclosure rules applicable to alternative procurement modes. First, let's look at the factual background. This case centers on municipal procurement transactions in Palawig, Zambales, which became the subject of a Commission on Audit review and subsequent legal scrutiny. In 2006, the municipality procured office supplies through the shopping method. Corazon Reyes, a Bids and Awards Committee member, faced a graft complaint because the winning supplier, Tabing Don Mart, was owned by her sister. The defense argued that no disclosure was required for the shopping procurement mode. The case progressed from the initial 2006 procurement to an FIO complaint in 2014, followed by an ombudsman finding of probable cause in 2017. Finally, in March 2023, the Supreme Court granted a petition for certiorari, setting aside the ombudsman's ruling and dismissing the graft charges. The ombudsman's grounds for finding probable cause were threefold: the supplier's ownership by a relative, the alleged failure to disclose this relationship under Section 47, and the nature of the repeated transactions as constituting evidence of manifest partiality and unwarranted benefit. The legal heart of the Supreme Court's ruling involves deconstructing the scope of Section 47 of the implementing rules and regulations, and clarifying the high evidentiary standard required to establish probable cause for graft under Section 3E of Republic Act 3019. The court emphasized a strict textual application of the 2006 rules, noting that disclosure requirements for relations were limited to competitive bidding. Expanding these penal interpretations retroactively to cover alternative procurement modes constitutes grave abuse of discretion. The statutory evolution table highlights that the 2003 rules governing the 2006 procurement were distinct from the 2009 revisions. The Supreme Court affirmed that you cannot apply later, more expansive requirements to judge the legality of acts performed under earlier, more limited regulations. A procurement violation is not automatically graft. The prosecution must prove a specific mental state, evident bad faith, manifest partiality, or gross inexcusable negligence. Because the supplier offered the lowest price and the government incurred no loss, the necessary corrupt intent was absent in this case. Ultimately, the court reaffirmed three key doctrines: that procedural lapses without proof of fraud cannot sustain graft charges, that grave abuse of discretion justifies judicial intervention in ombudsman findings, and that securing an advantageous bargain for the government rebuts claims of bad faith. For BAC members, the guidelines are clear. Ensure compliance with the rules in force at the time, disclose interests voluntarily to prevent conflict, document all price advantages, and distinguish between administrative oversight and the specific intent required for criminal graft liability. This concludes our summary of Reyes versus the Office of the Deputy Ombudsman for Luzon. Thank you for viewing this lecture on public procurement. This summary slide serves as a conclusion to our session on GR number 230704 regarding anti-graft law. This final slide lists the image source used for the visual elements of this video.